Good afternoon, ladies and gentlemen. It's my great pleasure to welcome all of you to the conference of today about the cyberspace, jurisdiction, and conflict of laws. It is a joint venture of Christopher Kuner and myself, of the MPI and the University of Brussels, and it's our great pleasure that so many people came to Luxembourg, but I would say the topic we are addressing today is really one of the big challenges of today. If one looks here in Luxembourg to the case law of the Court of Justice, you can see that data protection has become a recurrent issue. The data protection regulation will enter into force next year, so member states are preparing the implementation and it will change the scene. But it is not only Europe where developments are happening, it is, of course, we are talking about the cyberspace, a global development. And I think now I should give the floor for a moment to Christopher.
Thank you very much, Burkhard, and really just very briefly, on behalf of the Brussels Privacy Hub at the VUB Brussels, I'd like to thank all of you for coming, for all of the speakers and discussants who will be participating, and I'd also like to thank Burkhard Hess and the entire team of the MPI here for the wonderful organization and helping to make this possible. I think we can already see how well things are being run and how successful this day will be. I think when we first discussed this event, we were sure that the timing was right for it and the topic was also right. And I'm confident that the discussion today will confirm that point of view. I'd also just like to also agree with what Burkhard said about the global aspect of this. Of course, it's inevitable. A lot of the discussion today will revolve around EU law and the EU experience, but we also want to keep in mind the global dimension, and we have some speakers who've demonstrate that by coming from very far away to participate here. So thanks in particular to them. And with that, I suppose we can get started.
Yeah, you're absolutely right. One last word. As you might have realized, we are going to film the event. There will be a YouTube video available in a couple of days, which means that the moment you step in to contribute to the discussion, it would be very nice if you present yourself very briefly. And as far as the discussions are concerned, our idea is to have a very open discussion, debate here in the room. There will be enough time for our debate, but on the other hand, please keep a certain limit in order to give also other people the opportunity to speak. So now I'm happy that we can start. I wish you and to all of us a very interesting afternoon. And the floor is now to Jan von Hein.
Well, thank you to Professor Hess and Professor Kuner for inviting me here to this splendid event. I have the honor of chairing the first panel of our session. I have first to make a rather sad announcement that Paul de Hert, our discussant for this panel, is unfortunately ill, so he cannot join us this afternoon, but nevertheless, I think that the topic is of such an interest that even without the very highly esteemed input of our colleague, we will have a fruitful and lively discussion. I'd like to introduce to you our speaker for this first panel. It's Dr. Fruzsina Molnár-Gábor. I probably pronounce this very terribly because my Hungarian is not very good. It's rather inexistent, I have to admit. Dr. Molnár-Gábor has acquired a PhD from the University of Heidelberg in 2015 under the supervision of Silja Wönicki, who's now a very dear colleague of mine in Freiburg, also an example of the good and friendly relations between Heidelberg and Freiburg, and Professor Rüdiger Wolfram, whom you all know, of course. The subject of Dr. Molnár-Gábor's thesis was the international regulation of biotechnology by the example of new methods of genetic analysis, so a very far-reaching interdisciplinary work on these difficult issues of biotechnology. She is currently a member of the WIN colleague, the W-I-N colleague, the Junior Academy for Young Scholars and Scientists at the Heidelberger Akademie der Wissenschaften, the Heidelberg Academy of Science. There she works on the academic project Data Protection and Data Exchange, and more specifically on the legal issues of biopatents, biopatenting. The precise title is The Patent System as a Medium for the Ethicalization and Politicization of Stem Cell Research and the Consequences of its Expanding Function for Life Sciences. She is also serving as a member of the Ethics and Governance Committee of the International Cancer Genome Consortium. Today, she will share with us her thoughts on data protection and fundamental rights law, in particular the example of cross-border exchanges of biomedical data, in particular the case of the human genome. We are very honored that you're here today with us, Dr. Molnár-Gábor, and the floor is yours.
Yes, hello everybody. So for the introduction, my name is Fruzsina Molnár, and it's a great pleasure to be here and a great honor. So thank you for inviting me, and thank you for this lovely introduction. The pronunciation of my name was up to 99% perfect. Okay, so my topic is data protection and fundamental rights law, and if you excuse me, I'm going to read this out for the most part because I would like to be as accurate as possible. I will give you first a short introduction on human genetic research as it is conducted at the Heidelberg European Molecular Biology Laboratories, and I think this introduction will make it possible for you to realize that the issues that we are dealing with from the legal perspective are issues that are actually of general matter. So I think the whole presentation will be relevant for data protection law as such, and not only for the regulation of biomedical research. Yes, this is working great. So the raw data for the 3 billion nucleotide-based human genome sequence, which was completely decoded in 2003, was generated over several years, as you're probably aware of, for $300 million. And this decoding of the genome has augmented our understanding of molecular life processes, because depending on certain alignment and reassembly of sequence fragments, sequencing technology allows a really high throughput base-by-base view of the genetic material, and it provides researchers a tool to probe genome architecture in really unprecedented depths. And when then subsequently combining this genetic data with other molecular data types, then even more uniquely rich data set occurs, which further enables integrative analysis to be carried out in even greater depth and to enable further insights into molecular disease processes. This systematic evaluation of results from this comprehensive genetic and molecular database examination shows that there will be a lot of findings whose validity and exact medical relevance still needs to be deciphered, because the accuracy and health relevance here depend on scientific advances, on certain informational interpretational patterns, such as bioinformatic filters, and also on the influence of further factors, among others the role of environmental impact on patients or certain lifestyle aspects, such as nutrition. So because of this, the gathering of further health-related data about the persons that are investigated beyond the cellular level is also becoming extremely important and very relevant for this research. And when then combining all this data with clinical data, then this may inform the development of really pioneering diagnostic and treatment strategies and enables a move towards personalized medicine, which I think is quite a buzzword that you have all heard. So in order to associate a genetic variant with a clinically important trait, high statistical validity is necessary, primarily due to the high heterogeneity of most genetic and genomic-based disorders and diseases. And comparative analysis across specimens collected by individual projects is something that helps to uncover commonalities and differences in the development and progression of different types of severe diseases, such as cancer or inherited genetic disorders. So it is coming a part of the analytical approach of this research to broaden its focus and to include a vast number of correlations and findings from the combination of every kind of genetic mutations and variants and other molecular data. So the more comprehensive the data analysis, the higher the chances to identify the cause of a disease and the probability of its outbreak, and to draw then predictive conclusions. In the meantime, whole human genome sequencing costs €1,000, and it's a push-button technology and minimal hands-on time with tabletop sequencing machines that enables researchers to interrogate a complex human genome very quickly and efficiently. And this has spurred several large-scale initiatives in genomics research all around the world. For instance, I'm sorry, this seems not to work, the slides. Could you please give me a hand on this? Thank you. So it has spurred several large-scale initiatives all around the world, such as the 100,000 Genomes Project, the pan-cancer analysis of whole genomes, and the International Cancer Genome Consortium. And according to researchers that are participating in these projects, several 100,000 to 1 million human genomes are expected to be sequenced and analyzed in the next few years. And sequencing of only a few thousand whole human genomes, and their combination then with other molecular data generates approximately 1 petabyte, so 1 quadrillion bytes of data. So you can imagine what kind of big data is going to be established here. There are certain aspects of this research that have data protection relevance. I think it's already obvious. Firstly, most of the data that are used in this research are personal data, very short sequences of the human genome. 13 base pairs allow to identify a person, and much of this data is, of course, particularly sensitive. And secondly, the probability of being able to identify a pseudonymized or an anonymized sample donor is increasing if data diversity and data quantity are increasing. There are certain disease studies that information about disease diagnosis and ethnicity and the age of the patient already allow the correlation and the identification. Thirdly, then in many medical research use cases, it is not fruitful to completely disconnect data from all identifiers, because this would block the transfer of those results back into clinical settings. And fourthly, as I have indicated, such research ventures use joint data that has been collected across research centers from all around the world, and they rely on global data sharing, which includes transborder data flows, but also providing access to data collections. And they use cloud computing technology to achieve their aims, because this enables a comprehensive integration of diverse data sets and also the global sharing and collaborative processing of data. The problem is that most academic research centers do not currently process the IT infrastructure that is required to merge this information and to store it and to jointly analyze it. So there is an increasing outsourcing of IT technology to global public cloud providers. And we all know they operate data centers in different geographical regions, and they process data according to the availability of compute power. So they often hold data in cache files, or they make copies in unrevealed geographic regions to allow for seamless processing. Okay, I think I will make it's working, this very short, because I think we are all aware of the certain differences that are prevalent in data protection regulations around the world. There are varied approaches which really propose significant challenges to this multicentral biomedical research and for data exchange. And because the scientists that I am working with usually exchange data within the EU and with US American companies, I will focus these two regions. And please just allow me to broadly maybe summarize some issues that are relevant in the EU. You all know that data protection regulatory framework has a fundamental rights character. Article 8 of the EU Charter of Fundamental Rights defines it, with the EU secondary legislation determining then its meaning. And this is a general and uniform protection with public and private actors generally falling under the same legislation, of course, and the enforcement of data protection regulation by independent national supervisory authorities occurring then parallel to the enforcement of judicial authorities. Okay, thank you. I will try. I have a lot to say, but maybe I will cut it during talking. So after the implementation of the Data Protection Directive, which was the preceding regulation, there was still a very fragmented evolution of data protection in the member states, and the only similarity, according to main scholars shared by all member states, was that they all have data protection laws, and they were somehow linked to rights that were regarded to be constitutional or somehow of equivalent importance. And the General Data Protection Regulation, which will come into force in May 2018 or has to be implemented by all member states, aims to secure an even higher level of protection of personal data in all member states, and this through an applicability to a broader range of personal data processing activities and granting individuals more rights in relation to a broader range of data categories. But there are still different regulations and flexibility clauses in the GDPR, so that it will be basically left up to national legal systems to each member state to determine the procedural rules under which those EU rights are going to be protected that are defined. And this is, of course, subject to the requirements of effectiveness and equivalence, but still the GDPR provides member states with room to maneuver in specifying its rules so that member states will be able to go beyond the provisions of the GDPR and add provisions regarding specific data processing situations, including those of the processing of special categories of data, such as sensitive data, which is relevant for this research. And so to this extent, the GDPR does not exclude member states' law, that sets out the circumstances for this specific processing situations, also including determining more precisely the conditions under which the processing of personal data is lawful. I have listed here a few examples, Recital 10 of the GDPR, 153, and maybe very relevant for scientific research is Article 89, which can serve as a concrete example how the right to data protection of personal data can be limited in favor of freedom of research. This means that where personal data is processed for scientific purposes, member state law may provide for derogations from the right to access by data subjects, the right to rectification, and the right to restriction of processing, and the right to object. And critical voices claim thus that member states' room for implementation of the GDPR carries further the risk of fragmentation and inconsistency of European data protection law, which could have also a negative influence on European data sharing in scientific research. I will make USA very short. I think you are aware that the application of the Fourth Amendment is limited in the US to those places, things, and actions in relation to which the individual has a legitimate expectation of privacy. So every time a data transfer is voluntary, this excludes information individuals' voluntary turnover to third parties. So this data protection model is essentially based its approach around the concept of freedom as a protection against interference by the state in the life of individuals. And in contrast to the EU, there is no horizontal data protection legislation that would be applicable to both public and private actors alike. And the private sector is governed by a mixture of ad hoc legislative initiatives, industry self-regulation, and market forces. And there is also no supervisory authority, and federal courts can only bring about a limited range of changes in conduct under the 1974 Privacy Act, and they do not have any powers to compel federal agencies to change their overall general practices. So this privacy regulation is limited in the private sector, restricted to the areas that are limited, and the idea of a supervisory authority also having been rejected. This is a field that is largely unregulated and lacks effective rule enforcement. So there are also, of course, private sector cross-border frameworks and data sharing. Yes, that is specific mechanism for the transfer of personal data to be used by private parties engaged in trans-border data flows. And these are supposed to provide for harmonization based on global values that are shared or common in a certain processing sector, and in this way provide for further harmonization. However, I think that such specific mechanisms have to date been subject to state approval, and with the public authorities involved like the EU using said approval to aim for the protection of data processed abroad by mandating the continued application of the law of the place of data collection or data export. Such mechanisms are accordingly almost, well, if I may put it that way, doomed to fail to provide factual harmonization of data protection standards. The decision of the EU Commission, which you can see in a picture on the adequate level of data protection in a country of data import, is based on whether the country's law complies with EU data protection standards, and this requires, of course, the regulations of the agreement that allows for the data exchange to reflect the fundamental values recognized by the EU, especially in relation to standards of fundamental rights and the rule of law as provided by the EU regulations. However, many scholars have pointed out that the Privacy Shield also fails to sufficiently respect those values, with grave violations of the rule of law and of fundamental rights protected by EU law. There is already the privacy advocacy group Digital Rights Ireland, who have claimed that the European Court of Justice should declare that the EU Commission implementing decision on the adequacy of the protection provided by EU-US Privacy Shield represents, nota bene, a manifest error of assessment by the Commission. I like this framing, manifest error of, assessment, insofar as it finds that an adequate level of protection for personal data in the US is given, and that it should declare that this contested decision is null and void and order its annulment. So we will have to wait and see how it develops with the Privacy Shield, but I think it's no secret from the perspectives of scientists that these data transfer frameworks have until now tended more to result in a disconnection of regulations from biomedical advances, and they altogether hinder the sharing of scientific data. So in the light of these developments, there have been recently a drive to create new regulatory solutions for cross-border data sharing within the EU and also on a transatlantic level in biomedical research via the establishment of so-called codes of conduct. And codes of conduct, I will try to establish a short definition. They should be seen as private sector initiatives for the regulation of data processing and the establishment of professional standards based on a bottom-up approach. So generally, when confined to a single jurisdiction, they present an alternate to the traditional options of inflexible legal rules, if one might say, on the one hand, and of course ethics statements developed by professional societies or quasi-governmental bodies of uncertain or non-existent legal relevance on the other. When they are widely embraced, then guidelines for professional conduct can in fact be more effective than laws and regulations, which can be blunt regulatory instruments formulated maybe in a too general a manner and which change too slowly to keep pace with this cutting-edge research. The establishment of professional codes of conduct normally relies on the involvement of experts, which confers them disciplinary and sectoral appropriateness and maybe a factual legitimacy, if I may say, enabling scientific knowledge to be directly translated into a normatively orientating knowledge. So that for the general level, and codes of conduct, of course, have already had observable legal effects, for instance, in Germany, regarding liability in civil law or regarding labor measures. We can discuss that later. We also had in Heidelberg an example with legal relevance by the implementation through public legal entities such as universities. We wrote such a code. So recently, with much accompanying fanfare, codes of conduct have been coming to generally be seen as also being capable of overcoming the fragmentation of various data protection regulations. And Article 40 GDPR encourages the drawing up of codes of conduct intended to contribute to a proper application of the regulation, taking into account the specific features of various data processing sectors. Within the EU, the biobanking and biomolecular resources infrastructure network. I did not. Okay, so it's the other way around. I'm so sorry. I was thinking backwards, so that is the BBMRI. They are preparing a code of conduct for data sharing in health research that is scheduled to undergo approval by the European Commission by 2018, May, and I'm a part of the drafting group, so this is quite interesting. And also the Global Alliance for Genomics in Health has been developing comparable guidelines for the US EU data sharing. So the question arises whether a code of conduct approved according to Article 40 GDPR could have a significant influence on a harmonized approach to the understanding of the fundamental right to data protection in the EU. Associations and other bodies, according to this article, representing categories of controllers or processors may prepare codes of conduct for the purpose of clarifying the application of the regulation. So codes of conduct may only clarify, but any aspect of the GDPR in order to facilitate its effective application, including but not limited to the points that are listed in para 2. However, the GDPR is the regulation that remains the legal basis for the processing of a data. So a code of conduct can take account of the specific characteristics of the processing carried out in a certain sector, but specification, but maybe to put it better, clarification through the code of conduct can only take place within the limits of the GDPR. The GDPR, as I have already noted, is applicable to a broader range of personal data processing activities than the DPD was, and grants individuals more rights in relation to a broader range of data categories. And this enhanced control of the data subject has basically two functions. One is a conceptual function. It means that this is exercised by identifying different forms of harm that could be caused by personal data processing and which limit individuals' negative freedom. And the second is, of course, an instrumental function exercised through the subjective rights granted to individuals in relation to data controllers and processors. So accordingly, the GDPR lays down various rights and specifies the fundamental right to data protection in a very progressive manner through a whole string of subjective rights. So a code of conduct on data sharing in the context of biomedical research must therefore respect this understanding. In principle, the EU fundamental rights apply within the scope of union law. So these aforementioned GDPR regulations provide member states the necessary room for the adoption of implementing measures, ensuring a reasonable balance between the various fundamental rights protected by the legal system of the EU and its member states, because within this interpretational room, member states must also respect their own national fundamental rights in addition to those of the EU. So the legitimacy of these flexibility clauses in the GDPR is rooted in the desire to respect domestic law. And this is undermined by the fact that the EU fundamental right to the protection of personal data, granted under the EU Charter of Fundamental Rights, only exists once the scope of EU law takes effect, as per Article 51 of the Charter. So again, against the backdrop of the aforementioned GDPR regulations and this relationship between EU fundamental rights and member states' fundamental rights, the question arises whether heterogeneity in member states' implementation of the GDPR as regards the rights of data subjects has consequences for a code of conduct's prospects of approval by national supervisory authorities. Yes. So the question I ask myself, what role do member states' supervisory authorities and even more so member states' divergent implementations of the GDPR play in the approval of any sectoral code of conduct according to the GDPR? Regulations on supervisory authorities are included in Article 51 and sequences in the GDPR, and the crucial factor is their independence from any external or governmental influence. This is also prominently regulated. You can't see it, unfortunately, cited in the Treaty on the Functioning of the EU, Article 16, and also in the Charter of Fundamental Rights, Article 8, Para 3. So supervisory authorities exclusively examine, according to this regulation, draft code of conduct's compliance with the GDPR, and they approve said draft codes if they found that they provide sufficient appropriate safeguards for compliance. Special approaches to any implementation or derogations in member state law should not be considered, according to this article. So the question is if member state supervisory authorities are obliged to approve code of conducts which meet the provisions of the GDPR, but they do not reflect the level of data protection which the supervisory authority would consider necessary according to the respective member state law. And considering the purpose of the code of conduct, namely to clarify the GDPR, and with regard to the supervisory authority's obligation to encourage the creation of such codes of conduct, it is, I think, quite safe to assume that there exists an obligation on the part of the supervisory authority to approve them. So, in view of the approval of such codes, which will be applied in several member states, this certain power of member state supervisory authorities is further weakened in light of their obligation to submit code of conducts to the European Data Protection Committee for an opinion. However, opinions issued by this body are not binding upon member states, so supervisory authorities can even decide in this case. If a favorable opinion is given, then the supervisory authority may still reject it. The test is again, however, compliance with the GDPR, not with member state implementation. There is also the possibility that this decision of the board is binding, but I will not further elaborate on this. So then the next step is the respective supervisory authority approves the code according to the opinion and then submits it to the Commission if the opinion of the committee is favorable. So, taken as a whole again, the question arises whether the EU GDPR, through the backdoor instrument of codes of conduct, robs member states of the opportunity to make use of the flexibility clauses of the GDPR and to derogate from its rules. The answer is, in fact, that it does not. May I ask for further assistance? Oh, great. So, it does not rob them, it's my thesis, because EU law, and thus also the implementing act of the Commission deciding that an approved code of conduct has general validity within the Union, has priority over member state law. This priority only applies to the extent that member state law contradicts Union law. That member states will derogate from the GDPR is, however, foreseen in the GDPR itself. Also, the Code of Conduct does not provide a legal basis for the processing of data, but instead it only helps to effectively apply the GDPR in specific processing scenarios. So this mentioned implementing act of the Commission has to be consistent with the GDPR. That means that it has to respect also its flexibility clauses. So the consequence is, I think, that codes of conduct can provide, through the clarifying application of the GDPR, for further harmonization, but only for those rights of data subjects that cannot be subject to derogation in member states, and that's quite many. Or where they concern such rights that can be subject to derogations, then in cases where member states did not make use of their ability to derogate. So we will have to wait and see. However, as so often in life, the proof of pudding is in the eating. So there are concerns, even this legally unjustified presumption, that the unity of approval decisions reached by member states, supervisory authorities regarding codes is going to be endangered. We are drafting the BBMRI draft code of conduct, and here we can already observe the rise of an approval-seeking tourism, I would call it, so that requests for an approval tend to be submitted in different countries because it is assumed that codes of conduct will likely only have a chance to make it through the approval process if they broadly respect member states' implementation of the GDPR, particularly where member states have used their interpretational room to err on the side of strictness. This assumption is, however, not justified, and maybe people who are sitting here and have experience in practical data protection authorities' approvals might bring in the discussion some reasons that they think might be a reason for this approval tourism, even if it's legally not justified. At the same time, I think we can conclude that the harmonization effect of codes of conduct on data subject rights can only be sectoral, because codes are going to specify and clarify the application of rights in a sectoral manner. So the question arises if codes of conduct are going to pave the way to a further fragmentation of data protection, not member state level, but sectoral fragmentation. And I think the answer is yes, and I think that this is ultimately inevitable because data can only be considered personal in specific processing contexts, and privacy and the right to data protection of personal data can only be defined in a contextualized manner. So we will have to deal with this. As the next panel is going to consider transnational data flows, I'm going to make the next point quite short. I would just want to highlight what kind of relevance codes of conduct have in transatlantic data sharing and what is the assumption and whether it is justified or not. So I already elaborated shortly on the Privacy Shield and its mechanisms that are also, according to the Article 29 working group, do not really allow an effective exercise of data subject rights and undermines this. There are concerns that all recourse mechanisms foresee proceedings taking place in the US, and this complicates the monitoring of the procedure by the EU DPAs. And in fact, the recourse mechanism provided for in the Privacy Shield concentrate primarily on the possibility for the data subject to firstly vindicate their rights and pursue cases of non-compliance through direct contacts with the US self-certified company. Complaints could be directly lodged with the Federal Trade Commission, but the FTC has no duty to deal with them, so data subjects do not have any certainty what will happen with their complaints. They can invoke binding arbitration in the US, but they cannot bring claims for damages in the European Union, and they are not granted the right to lodge a claim before a competent EU national court. So the question is if this is going to change, if there will be an approved sectoral code of conduct. I think to a certain extent, yes. It's the same article I have already shown you, Article 40 and Para 2, J. Associations and other bodies representing categories of controllers or processors may also specify through a code of conduct the GDPR and its application as regards transfers of personal data to third countries or international organizations. In addition to adherence by controllers or processors that are subject to the regulation, these codes can be approved. Also, and maybe adhered to by controllers and processors that are not subject to the regulation, so for instance, US companies, in order to provide appropriate safeguards within the framework of personal data transfers to third countries or international organizations. And such controllers have to make binding and enforceable commitments via contractual or other legally binding instruments to apply said appropriate safeguards, including those relating to the rights of the data subject. And the EU Commission may, by way of implementing acts, decide that these approved codes of conduct have general validity in the EU. Now, an implementing act is an EU legal act, and because of this Article 47 of the Charter of Fundamental Rights applies, I think, meaning that infringements of the Code of Conduct represent an infringement of Article 8, the protection of personal data in the Charter of Fundamental Rights, so it could be challenged before courts. Hence, legal protection can be sought in bringing action against unlawful or inadequately enforced codes if data processors have bound themselves legally to the treatment of data subjects. Nevertheless, US companies would have to make binding and enforceable commitments, as I already said, in order to be covered by the Code of Conduct. And if this approved Code of Conduct represents an extra instrument in addition to the Privacy Shield, there would be very little incentive to do so, with participation in the Privacy Shield framework already providing authorization for any data processing. So we will have to wait and see, but I think there will be very little motivation for such a commitment on the part of US companies. So the question is, which I will pose also on my last slide, what incentives can be put in place to reach this? I really do not want to extensively elaborate on the question whether codes of conduct are going to change anything regarding the critique also from the Court of Justice of the European Union that state authorities in the US have extensive possibilities to access data based on national security thoughts and measures. So I don't think this is going to change by a code because US companies are further obliged to provide law enforcement agencies, for instance, with data for the purpose of protecting national security, and if they enter into agreements within the framework of Code of Conduct to not provide US agencies with respective data sets, they would then have to choose whether to neglect either their domestic or their contractual obligations, and I think this is not a question which is difficult to decide how they will decide. I think the question is more if it is really justified to criticize these measures regarding national security with regard to GDPR Recital 16, which states that the regulation does not apply to issues of protection of fundamental rights and freedoms, considering activities concerning national security, so it's a comparable regulation also in the EU. I'm not sure. At the same time, the expectations of the Global Alliance for Genomics and Health by drafting a code is that codes will help to avoid national security reason access to data. I am not sure what their argumentation is. I don't think this will help. I think there is one way this might help, and this is attached to the status of scientific freedom in the EU, and if it can be realized as self-regulation, including privacy by design. So this is my very last point. I will very shortly elaborate on the status of scientific freedom. Do I have time at all? I do have, thank you. Okay. And what this means for privacy by design. So maybe in advance also that such measures are already emerging, such as federated clouds or the EOSC is the European Open Science Cloud. And their emergence is really particularly relevant in the light of this specific standardization of scientific freedom as a fundamental right in the European Charter of Fundamental Rights. This can be, I think, understood as an EU position for setting values, given that the freedom of research cannot be determined with such a clarity in the shared constitutional traditions of the member state or the guarantees by the European Convention on Human Rights. Parallelly, the promotion of science is one of the EU's objectives and is supported by the EU treaties. This is Article 3, Paragraph 3 in the treaty. The European Union and also the Treaty on the Functioning of the European defines the European area of research and stipulates that the EU has the objective of strengthening its scientific and technological basis by establishing this research area. And the EU must support scientists' efforts to cooperate with each other, particularly so that researchers can cooperate freely across borders and that their activities can fully exploit internal market potential. So this could specifically be achieved by defining common standards and by removing obstacles to such cooperation, as stated in Article 179 of the Treaty on the Functioning of the EU. So the fundamental right of scientific freedom in the EU is primarily a defensive right. There is no entitlement to benefits for supporting research for the individual researcher or scientific establishment that could be derived from the Charter of the Fundamental Rights of the EU, Article 13. But the right to freedom of science guaranteed under this basic EU law requires, and this is Ohlenschläger who has established this thesis, that this requires that the support of research done by the EU institutions should be provided in a manner that is as suited to the needs of science as possible. And I think this is a very nice derivation of this right. And if we consider that basic and transnational genetics and genomics research is increasingly reliant on global cooperations, and this context can only work with high statistical validity and data sharing, the needs of science, this science must also include international data sharing and global scientific cooperation. So the question is, how can the EU ensure this? And I think that every regulation that is stipulated in the EU treaties should be taken into account when considering data protection regulation and the interpretation of the GDPR, because the GDPR is connected to the EU treaties as secondary law, must be interpreted in their light, in light of primary law, in order to be legitimate. So the requirements of scientific research must be given a weighting that is similar to that provided in the EU treaties. So in order to achieve this objective, efforts to increase technological connectivity in Europe and between Europe and other regions is really imperative. And I think the right way is to establish such technological solutions, privacy baked in if you wish. And of course, you need to involve technological experts and those scientists that know what is the way, and this would be certainly a relatively new interpretation what self-regulation means. And I will show you my very last slide, if the technology. Okay, you can't read it. Sorry, something is missing on the right, but I think it's still maybe readable. So I would like to pose 3 questions which we might discuss. Firstly, I have said that this fragmentation of data protection between member state level and sectoral level is something that is emerging. I would very much like to hear what you think about this. Then I have touched upon the question, how can US companies, well, not forced but motivated, to adhere to codes of conduct, providing better protection for data subjects. I do not see any incentives yet, so I would be very interested to know if you have any ideas on that. And of course, we can discuss privacy by design as a technological reality interpreted as self-regulation, private mechanism, and also this regard. I would be very interested if you have any further inputs for my research, and I thank you very much for your attention. And yes, the floor is actually yours. That's the plan.
Well, thank you very much for this very dense and detailed and really thorough presentation of the legal aspects involved in the data protection issues with regard to biomedical data. What I found very interesting, apart from the specific issues of biomedicine that you were talking about, were these general aspects of this problem, how the EU or state and governmental bodies may ensure that private self-regulation is exercised in a manner that is actually in compliance with fundamental rights and other legal imperatives. I was looking at Professor Spindler. We have quite similar issues, I think, with regard to self-regulation when it comes to financial reporting, where we also have private codes that determine the standards, and then the EU makes them binding by way of regulations and directives. So there are a lot of horizontal structural issues in EU law, I think, that are very interesting in the area that you're working in, far beyond this specific issue of biomedical science. So this is a very good example how general structural challenges of European law pop up in very different sectors and areas, and this is why the dialogue between experts who work in these different areas is so important. But I don't want to monopolize the discussion. We now have 15 minutes roughly for a discussion, so do I see any hand? Yes, there, please. The micro is coming.
Hello, my name is Hilke Heijmans. I do different things, but I'm here as participating to the Brussels Privacy Hub. I was triggered by a number of things. I found it extremely interesting what you said, and also, but my main trigger is the subject of fragmentation. There's a lot to say about it. I think, on the one hand, I fully agree with you that the system of the GDPR doesn't solve or doesn't solve anything or doesn't do anything when you talk about fragmentation between different sectors, or maybe also fragmentation meaning that data protection authorities only take data protection into account and not other fundamental rights. So it's an issue how to ensure that. On one subject I had my doubts when you were talking, that was about fragmentation and codes of conduct. I think if you look at the GDPR, it's explicitly written in a way to ensure that codes of conduct are a measure to prevent fragmentation. There's a whole procedure in place, you mentioned a little bit, but there's more to it, which basically means that if a processing operation involves more member states or is cross-border, which is all the cases you mentioned are, in that case a data protection authority cannot just itself approve a code of conduct. No, it has to go to the European Data Protection Board, and it has to follow the opinion of the Data Protection Board. It has not legally to follow, but there are all kinds of measures in place. If they don't follow, then another authority or the Commission can even go to ask the EDPB to come up with a decision. So there's a lot put in place exactly to prevent that. But what I found more interesting as a question is whether or not, and that's the other say, I'm not so afraid about fragmentation, but maybe the other way around, how to ensure that justified differences between member states are taken into account in this procedure. That is a question I find maybe more interesting than the other question, because I think the procedure put in place by the GDPR is exactly measured to avoid fragmentation between member states.
Would you like to?
Oh, yes. Thank you so much. Technology is not on my side today, sorry. So thank you for the comments and for the question. And I'm not sure if this measure to submit the code before approval by the supervisory authority to the board ensures harmonization, because the opinion of the board is not legally binding, as you also stated. If their opinion is negative, then the supervisory authority cannot approve the code, so then it becomes basically binding. But if it's positive, they can still decide. So I am not really sure. And being aware of how many codes of conduct are being drafted now, I know at least about 10 in the health sector, like who is going to submit first and who is going to win the race. I'm not sure if they're all providing, should they be all approved for harmonization. So I don't know if there are really enough procedural rules and the GDPR to provide for codes of conduct, at least to achieve sectoral harmonization. I'm rather skeptical on that. And yes, justified differences by member states is an interesting question, which I rather excluded in my presentation, but of course, legitimate differences according to the interpretation of fundamental rights have to be upheld. So I'm completely on your side. How we do this is the next question, which I will not answer now.
Thank you. The next question comes from Professor Gerald Spindler from the University of Göttingen. The mic is on its way.
Okay, thanks a lot. First of all, I just want to introduce myself, even though I'm just on the second panel, but we had been heavily involved in the drafting of the GDPR on side of the Germans, because these articles were more or less an inventions of the Germans when we pressed hardly the Commission to accept that, and they did it after all, but unfortunately not in a way that was the best. If you have a close look at it, not in Article 40 subsequential, but if you have a closer look in the articles before, you will always see that the supervising authority has to take into account the code, nothing more. That is to say, it's not binding. It's not binding the supervisory authorities, just to a certain extent, and we do not know to which extent, and the courts neither. They are bound by these codes of conduct. And okay, just to give you, let's say, my bias in that, it's not only that I work for the German ministry, but also I'm head of the council of the German Association for Self-Regulation of the Internet, with also a headquarter in Brussels. And so we would be very interested in how your codes would be looking like, and I can tell you it's a really hard game to get industry into these codes of conduct, because we have these deficits that they're not really binding. So you always are running into these problems that some supervisory authority won't accept, let's say, in practice, the code, even though it's being acknowledged by the Commission, because that has no binding effect upon the supervisory authorities. And for that reason, well, in fact, we had been glad that it had been accepted afterwards, but it could have been better.
That was, I think, the right last sentence. It could have been better. Yes, that's true, because I think even if it's an implementing act on the EU level from the European Commission, if supervisory authorities are independent, then yes. I rather can't add anything. You're absolutely right.
Thank you. Lady over there, please.
Thank you. My name is Tine Larsen. I'm the head of the Luxembourg Data Protection Authority, which is an independent supervisory authority, as we just heard. And I would like to defend the cause of the supervisory authorities today. Yes, the GDPR could have been better. We agree, we all agree. We also agree on this in the Article 29 working party, of which all the 28 data protection authorities are members. And but we also know that we are, as the predecessor to the future European Data Protection Board, we have to work together to make this GDPR a success and make it useful for the protection of fundamental rights and the benefit of the economy and development of research, if you want to. I mean, there are lots of reasons why we have to make this work. So I would say, from a perspective of a National Data Protection Authority and from the perspective of the Article 29 working group, I don't agree completely on your the way you put what you said on approval seeking tourism, and also on harmonization of only sectorial harmonization of, through codes of conduct. We have been seized by different organizations in health and medical area to review codes of conduct, and also from other sectors. And we would like to do this at the Article 29 level and not at the national level. And in order to streamline the application of the GDPR within the EU through these codes of conduct. And we want to do this not in a sector-specific way, but in a general way. So at the moment, we have taken, well, we would like to draft a general opinion on codes of conduct, which every sector can use, or write its own codes of conduct according to. But I must admit that this was not on the priority of the Article 29's working plan for 2017. And as we have other issues we have to tackle now, and that we are quite in a lack of resources, it will probably not be discussed this year, but it is on the agenda. We have taken it, discussed the matter and taken it on our agenda. Thank you.
Thank you for this information. Please be quick, because May 2018 is so near, and I think the most codes, at least, will be aimed to be submitted before this date. So it would be definitely very helpful to have some advice and guidelines on how to develop them. And maybe I will just use this short reply to underline that it was not my intention to question the role of data protection authorities. They're of course also, in comparison with US law, very, very important for the upholding of the fundamental rights of data subjects, and their independence is of course a crucial point in this matter. So just to clarify.
Thank you. Any further? Yep, down there, please. And then Professor Hess as next one.
Klaas Seestedt, University of Luxembourg, LLM student. Dr. Molnár, you raised a question for incentives for US firms to be held accountable or to be in compliance with such regulations. Is there, or do you see any room for setting a technical standard, for example, by at the WTO or WIPO, as then having the economic consequences? After all, there's lots of economic consequences related to these projects. Then maybe having a business incentive, so to speak.
I think that's a nice idea, because standards on a technological level are set currently by Amazon and Google. So I would rather be happy with something from WTO, WIPO. Maybe WTO might be more suitable, I think. But I don't know if this is realistic. Do you have any information of, or it was just popped out of your mind, or do you have any background information that this is happening? No? It's a pity.
I'm a little bit curious about the reality you are facing. So you are in this very interesting project of the human genome. You are working on a code of conduct together with other scientists involved. How do you make it? What is the content of these codes of conduct? Do you have a model which you elaborate further, or do you look what other groups are doing? How is it evolving? And when I was listening to you, it's the second time that I'm doing this, I was also very much concerned about the legal uncertainty you are facing, and also the risk which might arise, because you are combining different, let's say, legal system, different approaches to data protection. And at the same time, the projects are progressing and are enlarged and are successful and are supported. So there is a huge tension, to my opinion, in it. Maybe you can elaborate a little bit further on that aspect.
That's a big question. Thank you. I don't know if a few minutes are impossible, but yes, first maybe to the drafting of the code that I'm involved in. It's led by the BBMRI, so actually they take the lead and define how we work, and we actually use code of conduct examples. There is a very nice collection by UNESCO on the GEOBS, I think you pronounce it, website, where they gather all existing code of conduct, also which have biomedical relevance, and we do investigate on those. But of course, the process is more, as far as I have experienced till now, we are not very far with the work, more like a close reading of the GDPR, to look at what kind of issues will have to be specified according to certain life cycles of data in biomedical research. So that's maybe the most prominent work chain that I would identify. But we, for instance, still did not specify different subjective rights of the individuals, so it's very much a work in progress. And yes, application of different legal systems on the same data processing activities is a crucial point. I admit that. And I was also aware, I don't want to name any institutes in Heidelberg, there was this phase where the safe harbor agreement was not valid anymore and there was no privacy shield. And the data protection authorities in Germany stated that even standard contract clauses and binding corporate rules are not valid anymore because of the safe harbor judgment, but data processing was just carried on with these institutions, and no one said anything, so it's quite a crucial point. And I think this development towards privacy by design, for instance, developing analytical frameworks that can be sent to the data, so you don't transfer data, but you send the analysis framework to the data, might avoid some crucial conflicts between data protection laws, although there are then several other data protection issues which arise, because such analytical frameworks are learning systems, right? So when you apply those and they read certain data combinations, they might be able to recognize individuals afterwards according to these combinations, so the same data protection arises. And there is no definition in the GDPR what is data transfer. Data transfer is data processing. That is very much defined. Everything you do is actually data processing, but what is transfer? I mean, transfer is, of course, sending data, transborder data flows. It's also providing access to data in maybe other countries. Are such analytical frameworks, if they raise data protection issues, is that also something that has something to do, and if yes, what with transfer? So, yeah. Sorry, I posed like rather more questions than to answer them.
Thank you very much. So, this is another question, or yeah, okay. Then this is the last one by Professor Kuner.
So, Christopher Kuner, one quick remark is you. Besides the EU, you've been talking a lot about the US, but I assume that this sort of research is global, and there's probably a lot of research going on in India and China, et cetera. So your issues are probably much bigger. But I'm also wondering, or maybe a suggestion. The only other instance, I think, where there have been sort of private or non-governmental elaborated practices which have gotten for data protection, which have gotten approval by the data protection authorities, is binding corporate rules for data transfers. And there haven't been many EU-wide codes of conduct approved for data protection, but the experience of binding corporate rules also shows that there can be conflicts between them. So if you have multiple codes of conduct approved, you may find out that the rules for them may differ. And in theory, this shouldn't happen because you think they're approved by the Commission, they're approved by the DPAs, but actually sometimes they approve them under different standards. And who is going to keep track of this and be sure that these different instruments all can interact with each other? That's a problem in practice with data transfers, and it could be in medical research as well.
Yes. Sorry, I just can't add anything. You're absolutely right, and this will be a huge problem, foremost against the background of the huge number of codes that are in the drafting. Thank you.
Yeah, well, thank you again very much to our speaker, not only for her very lucid presentation, but also for her patient answers to all our questions. I would also like to thank all the discussants. And my remaining task is to make the smooth transition to the next panel on territorial scope of law on the internet, which will be chaired by Professor Kuner. Thank you very much.
Well, thank you very much, Professor von Hein. I think this is indeed a very smooth transition. And as the chair of this panel, I think really my only role now is to, first of all make some introductions. And I have to say, when I think of introducing both our speaker and our discussant, I get a headache, because they're both involved in so many things that I don't know where to start, and I feel that by introducing them I'll necessarily leave out something important, which I don't want to do, but I'm certainly not going to list everything. So we thought it was important to have a panel on this topic, because really a lot of the issues of jurisdiction, applicable law, conflicts of law with regard to cyberspace can be reduced down to the issue of how far should law reach. What is the territorial scope of law? This is where a lot of conflicts arise and questions about jurisdiction arise. So we have two very esteemed people to discuss this topic, and then of course again we'll look forward to questions from you. Now, Dan Svantesson, I don't think we could have anyone better than him to speak on this topic. Dan is a professor at Bond University in Australia. He has over the last 5 years, he's had the sort of grant that I think many of us wish we could have, which is to think about and write about jurisdictional issues with regard to the internet without having to do any teaching. That's quite an attractive proposition. And as a result of this project, which is just completed, and I'm sure he'll maybe tell you a bit about it, but Dan has produced so many writings and publications that my head almost explodes. I can't even begin to mention them. And I think recently, within the last 2 or 3 weeks, you've had like 3 books appear, haven't you, Dan? So, which doesn't happen even for very prolific academics, doesn't happen every day. And these books and these writings are all about jurisdiction and the internet. So Dan has thought about this very deeply over the last 5 years, traveled all over the world, participating in events, and really I don't think we could get anyone better to speak on this, nor do I think we could have anyone better than Gerald Spindler as a discussant. You've already met Gerald from his question, and besides being, I think, one of the most long-standing and eminent European, not just German, but European legal scholars who've been dealing with cyberspace and internet issues from the very beginning of the internet, way back. I can remember those days, unfortunately. That ages me, but I don't think there are many of you can. But I think we both can, Gerald. He's really established himself as one of the preeminent scholars in this area, not only in Europe, but internationally. And I'm always impressed that Gerald also gives lectures in Spanish at South American universities. That's quite impressive. And he's, of course, also involved in many expert groups of the European Commission. So has his finger in many different pots, and I think we'll probably have some very interesting things to say on this topic. So I'm going to turn the floor over to Dan, and then after Dan, I think, Gerald, maybe you can raise some questions or give a reaction, and then we'll open the floor to questions. So Dan, you have the floor.
Thank you very much. I've been promised, yes, didn't even have to say anything. It came on automatically. This is a wonderful place. I'm so happy to be here, and I want to start by obviously congratulating the organizers, because, as was mentioned already, this is very timely. This is a very timely event, and we're now at a time, I think, where we can start moving from just discussing these matters to actually moving to solutions. It's in a sense almost overdue. So my task is to talk about the territorial scope of law on the internet, and as I try to indicate with this very subtle subheading here, I'm not a big fan of how we deal with territoriality at the moment. I think we need to really reform this field as such, because territoriality in a sense is aimed to fill 2 functions, and it fails at both. It is meant to delineate how far-reaching our jurisdiction can go, and it's also meant to work, on the other hand, as a warning light that you should not interfere with other countries' jurisdiction by indicating them where your territorial reach goes. And I think it fails, as I said, on both of those. But this skepticism about territoriality is, of course, I'm not unique in bringing that up. Since the mid-90s, at least, we've been quite broadly agreeing that territoriality does not work very well for the internet context. And the typical things that we would say is things like, well, online is very difficult to point to the location of an activity. Online is very difficult to point to where data is stored, for example, and so on. We've also probably moved past that now and start realizing that another problem with territoriality is its location focus, in the sense of it's very easy to manipulate this system. If I want to have a link to Argentina, I can easily place my data in Argentina, and if I want to avoid a link to Argentina, I'll take my data off service in Argentina. So it's a system that is manipulatable, and that's of course not good either. To this we can add that territoriality, with the way the internet works, might make us point to several locations when we're trying to find one spot that we want to focus on for example, the applicable law or the jurisdiction. So despite all these problems, and despite all these problems being well recognized for a long, long time, it's still fair to say, I think, that our current paradigm is very much characterized by a territoriality thinking. Our thinking on jurisdiction takes as its sort of jurisprudential starting point. It's always the territoriality thinking. And today I want to talk about why that is, some of the problems that stem from it, and I want to try to move then, as I said, towards some sort of solution to how we move forward. And obviously, given the theme of today, in doing so, I'm going to focus almost exclusively on the data protection context. So why is it that there's so much attention given to territoriality? What should I aim at? Good. Well, if you look at the authorities that's normally pointed to when it comes to, in a sense, justifying why our focus is on territoriality, it's predominantly two sources that keeps coming up. It is the 1927 Lotus case that you're all probably familiar with, and it is the 1935 Harvard Draft Convention on jurisdiction with respect to crime. These are the two sources that very, very often appear, and I think Mills have described them as sort of a fairly ritualized account of the standard heads of jurisdiction would point to the Harvard Draft principles, for example. As you know, the Harvard Draft is the original articulation of the principles of jurisdiction we see everywhere, the territoriality principle, nationality principle, passive personality, protective principle, and the universality principles. Principles we take for granted all the time now, but they stem then from this 1935 document. And while we now take them for granted and apply them almost universally, that was never their intention of the drafters, really. The drafters had a very limited aim in scope in mind, being, as is indicated by the heading itself, limited to crime, and we often apply these principles in other settings than crime, and they were limited to legislative jurisdiction, but they are often applied in other settings too, without much discretion shown. So I think we are currently, in a sense, misapplying the Harvard Draft principles. That's my first claim. So what about the Lotus case? Then you all be familiar with that one, I'm sure. But while it's frequently pointed to as a source for territoriality, it's questionable whether that is a sort of sustainable practice. Leading scholars like Cedric Reingart in Utrecht have said that, in fact, this might no longer be a good source of law, and I agree with him. In addition to that, what we keep forgetting these days, I think it was about half a bench of the court at the time had issued dissenting opinions. So it was already at its time of decision, it wasn't a very strong decision. And if you look at the Lotus case, a lot of people, I'm probably offending people now, but a lot of people seem to be pointing to this case without probably having read it recently. Because if you start reading the case itself, there's a lot of complexities that seem to be ignored in broad statements relied upon, broad statements backed up by this decision. If you think about it, for example, as I said, international law normally distinguishes between legislative jurisdiction, adjudicative jurisdiction, and enforcement jurisdiction. But what was this case about? What was the Lotus case about? Which of these categories was it about? That's doesn't seem to be bothering people these days. We just use this as a generic reference for territoriality, and I don't think that is suitable. And another thing that I want to say is this. Imagine that we had started with a clean slate trying to come up with good rules for the internet environment. Would your starting point really be to draw on a case from 1927 involving colliding steamships? The analogy is not obvious to me, and I think it is the case that law allows us to treat different cases differently. So why are we so eager to take these old principles and apply them online? I think one reason is that there is a lack of decisions and authorities in the field. So the few that we have, like the Lotus case and the Harvard drafts, are being overemphasized. Yeah? Had we had a wealth of decisions, we would not have pointed so often to these ones, and we might have a more sophisticated approach, perhaps. Another one is this. I think that anyone writing a sort of introductory textbook on international law might be tempted to bypass the complexities of the jurisdictional issues by just referring to the Lotus case and the Harvard draft. It's easy to explain to students, and therefore these have been repeated often, these sources, the claim of territoriality, and I think that's done us a disservice in the long term. International law is also a field where there's a particularly strong respect for the writings of leading commentators, and I think that has contributed to it. And we have somewhere along the way, we've lost the understanding of why we focus on territoriality in the first place. If you go back to the Harvard draft, and we could say that the territoriality principle is probably the sort of crown jewel of a framework put forward in the Harvard draft. If we go back there, they actually discussed why countries are focusing on territoriality. Today, we just take for granted that we should focus on territoriality without questioning why. Yeah? And that, I think, is a serious mistake. I'd also say that we overstate, there seems to be the thinking that because territorial sovereignty determines the sort of sphere of operation of a state, in a sense, that we need to link sovereignty to the jurisdiction issue as well. I think that conflation is unhelpful. And apart from this, there's other aspects of why we so often focus on territoriality. I think it's been said somewhere that modern cartographies or maps is the technological midwife of the territoriality principle, the territorial sovereignty. I think maps motivated a very clear territorial thinking at the expense of nationality thinking. And of course, the internet maps differently to the real world. So maybe that fact alone undermines territoriality. And then there's underlying biological foundations. Even animals are territorial, right? So I think people are territorial in a natural sense, but I'm not sure that that should translate into how we deal with jurisdiction. So on the whole, I think a lot of our territoriality thinking is more of a mindset than it is actually based on any clear and definite legal principles. And that made me think of, back in 1969, John Lennon and Yoko Ono had a billboard campaign for peace, where they said, war is over if we want it, or something like that. Billboards, and the meaning being, of course, if we change the mindset, we can stop wars. So my message to you is that territoriality as a territorial concept, or rather as a concept of the foundation for jurisdiction, is over if we want it. All we have to do is change the mindset. We're already overemphasizing what the law is saying, so the law doesn't stand in the way. So the time has come to move on. So what about the problems with this field then? Well, I've already mentioned some, and the classical ones, like for example online, it's difficult to say where events take place and so on. But there's many other problems, and I think if we start with one that I mentioned just briefly, it's very obvious that territoriality alone can't account for how we should think about jurisdiction. If it could, we would not have things like the nationality principle and so on. Those principles shows that territoriality alone does not fully explain how we should think about jurisdiction. And it's clear also that state practice has already moved beyond territoriality. You can look at a case like the E-Date case, where they turned their attention to the center of interest. That's a move away from territoriality, arguably. And Chris Kuner, in an interesting article, has mentioned how EU data protection authorities have started engaging in audits outside the EU. That is also a state practice moving away from territoriality thinking, at least in its stricter sense. In some areas, this move from territoriality, as much as I want to see a move from territoriality, in some areas that has actually been very problematic. And one example is this right to be delisted, the Google Spain type scenario, where we now have DPAs pushing for a global delisting as a result of local violations of law. I think that is problematic. I'm going to talk a little bit about that. It seems like we moved from territoriality, but moved into sort of a Wild West where there's no principles applying at all, and I think that's unhelpful. So if the EU wants to see a global implications of a violation of a local right, are we really prepared to accept that when Russia, China, and North Korea wants global delistings based on the violations of local laws there? I think we need to be a little bit careful what we wish for in this field. And I think really, if you look at the Google Spain case as decided by the Court of Justice, it introduced a lot of nuances in how it approached this right. It's not an absolute right in the sense that the original content remains online. You can still find the content by searches that doesn't involve a person's name and so on. Yeah? So there's nuances in how we approach it. In a sense, it's more a right to a fresh sort of first impression. Anyone digging into the details will find the content that they're after. Yeah? And I think these nuances need to be reflected also in the jurisdictional sense. We don't have to have a global delisting in all cases. In some cases, I think it will be enough to protect this right by a local or at least European-wide delisting. In other cases, let's say, well, it's normally referred to as revenge porn, for example. There I can see a need for a global delisting, but that doesn't apply to all types of content. So we need to have a more nuanced approach in that. We can't, or sort of one size fits all does not work in this setting. And we often talk about this when, so the question being, in the ongoing matter after the Google Spain case, how broad should this, geographically speaking, how broad should the delisting be? And we talk about that as a matter of jurisdiction, but is it? The question of jurisdiction in its traditional sense was decided already by the court in the Google Spain case. They said they have jurisdiction over Google, yeah? So what we're dealing with now is not a traditional question of jurisdiction. I've described it elsewhere as scope of jurisdiction, or perhaps scope of remedial jurisdiction. And we need to deal with that as a separate issue, and it's becoming a very important issue in the data protection setting, like through the Google Spain matter with Canil going on now. But also you might have seen the Equistec case in Canada, where a Canadian court said that Google needed to take activities affecting what's available online, searched anyway online globally based on Canadian law. So this is becoming a big matter, and we need to approach it in a smarter way than what we are at the moment. I'd also claim that a strict application of territoriality is destructive, and that has been acknowledged for some time. If you look at 4.1c of the Data Protection Directive, it makes an exception where equipment is used only for the purpose of transit through the territory of a community. Yeah? So that's clearly a step away from territoriality in a strict sense too. And I think if we accept it in that transitory setting, maybe it's not such a fundamental step to then accept that we can't rely on location also in cloud storage situations and so on. We need to move on from that. Now, I can't come here and have such a great opportunity to talk about matters like this without also mentioning Article 3 of the GDPR. I think there is a lot wrong with Article 3 of the GDPR, which outlines the sort of scope of application of the regulation. And on its most fundamental level, the problem is this: it's far too unsophisticated. It takes an all or nothing approach and says that either an organization is governed by the whole regulation or it's not governed by the regulation at all. But an instrument like the regulation contains a great diversity of types of provisions. Yeah? Some provisions are more or less, well, quite widely accepted. Abuse prevention provisions, like you can't, if you look at Article 5, certain principles around how processing of data should take place. They are widely respected around the world. Others are much more bureaucratic in nature. For example, Article 37, which requires certain organizations to have a data protection officer nominated. Yeah? I don't think we can have one jurisdictional hurdle for all those different types of substantive law rules. We need a layered approach for how we approach it. So let's say that we have an Australian company that happens to occasionally sell to European consumers. It might be reasonable that company has to comply with Article 5, the principles around processing. It might also be reasonable that it has to comply with Article 15, dealing with right of access and so on. But it might not at the same time be reasonable to demand that the Australian company in question should introduce a data protection officer. So we need to break it up in layers and assign different jurisdictional hurdles to these different layers. And you can do it in many ways. I put forward one proposal here, but you can of course do it in many different ways. Obviously the drafting of Article 3 is done, and we've lost the fight in that setting. But when it comes to the interpretation of Article 3, I think we can still rely on this layered reasoning. Because it's simply impossible for the DPAs to pursue every foreign company that is violating any of these provisions. And it would be silly to spend the efforts, the limited efforts that are there on pursuing an Australian company for not having a designated data protection officer if the actual processing is sensible and complies with Article 5. Yeah? So in the interpretation there needs to be some proportionality, and this layered thinking could be pursued there. And I hope that this working group, the ILA working group on data privacy, I hope that you take up this layered approach, while our friends in Brussels ignored me on that occasion as well. Right, so let's move on. Another problem here is the matter of extraterritoriality. There's two problems with extraterritoriality. First of all, as a concept, it doesn't work, and as a concept, it doesn't tell us anything useful. Yeah? We will never be able to clearly delineate when a jurisdictional claim is extraterritorial and when we are not. There's certainly not close to any agreement in that field. Yeah? If you ask people about does the Article 3 give the regulation an extraterritorial scope, some will say yes, and others will say no. I would say that be on the yes side, but there's some argument for the other side too, of course. So we can't define what is extraterritorial and what is not. I say that extraterritoriality as a concept is useless because it doesn't tell us anything useful. Some people try to say territorial claims are legitimate, extraterritorial claims are illegitimate. That's a complete misunderstanding, right? Otherwise, how could we have a nationality principle? Yeah? The nationality principle, the existence of a nationality principle, saying that you can legitimately base jurisdiction of the nationality of a person in question, shows that extraterritorial claims might very well be legitimate too. So it doesn't tell us anything, and it's difficult to pronounce. Every conference I attend, there's someone, and it's typically me, mispronouncing extraterritoriality, so I think we should get rid of it. I say also that territoriality is part of a dysfunctional system, because I think international law is full of very political, absolutist statements that you can never reconcile. So you can often find some statements supporting a particular position, and you find another supporting an opposite position. So I think there's some certainly big issues there. If we want some sort of absolute sovereignty, we can't have things like the effects doctrine and so on, and still we have them both. I'll skip the next one and go to the third. I think what we're seeing then through our attention to the Harvard draft and our attention to the Lotus case and so on is a cementation of 1920s, 1930s thinking of the world. And the world has moved on a lot, and we should move with it too, I think. It's unhelpful where we're at now. And to illustrate just how long ago, 1935, the year of the Harvard draft, how long ago that is, it's useful to look at what else happened that year, and I've shown this slide before some of you would have seen it. In 1935, they introduced canned beer, so that's how long ago we're talking, and a driving test became introduced in Great Britain. It's another world, isn't it? Radar was something that people were experimenting with, and paperback books were released. And this type of underwear was apparently released in 1935. And I normally make the point that I think there's a connection. In a sense, this underwear is this perfect symbol for territoriality. Some will look at this underwear and say that they look sort of cosily supportive. And they are probably the people who also think that the territoriality principle is cosily supportive. I look at this and think they look uncomfortably restrictive. And that's exactly how I feel about the territoriality principle. It restricts our thinking too much, it's not good. So what should we have instead? What is my recommended solution? I would like to see us move to this framework as the, in a sense, jurisprudential framework for jurisdiction. So this would be the core principle based on which we approach jurisdiction. So I'll read them. In the absence of an obligation under international law to exercise jurisdiction, a state may only exercise jurisdiction where there is a substantial connection between the matter and the state seeking to exercise jurisdiction. The state seeking to exercise jurisdiction has legitimate interest in the matter, and the exercise of jurisdiction is reasonable given the balance between the state's legitimate interests and other interests. This I see as a suitable alternative, and I think we need an alternative to territoriality. If we just remove territoriality, we'll end up with this sort of Wild West where everyone tries to grab jurisdiction as broadly as they can. They need to have some limiting principles, and actually these principles, I think, summarizes both public international law and private international law's approach to jurisdiction. And one thing I should say, territoriality is then not disappearing, it's just it's not seen as the core principle for jurisdiction. It can still be relevant. When I'm speeding in Australia and get pulled over, of course Australia has a legitimate interest in and substantial connection to my speeding offense, and there's no real competing other interests that outweigh those interests. So it's very clear that territoriality will be applicable for jurisdiction in maybe 98% of the cases. But these principles give us greater room to deal with complex situations. So in a sense, I also should emphasize, I see these principles being drawn both from public and private international law as in fact showing that the people who's been saying that these disciplines are closely related, if not the same as far as jurisdiction is concerned, I think these principles can be seen to prove that point right. At least I think so. Now these principles, I'm convinced that they are striking some happy medium, because sometimes when I present them, I'm accused of not saying anything new at all. And sometimes when I present them, I'm accused of being a crazy radical that's going too far. So surely they are hitting some sort of middle ground, I think. And they are, of course, not new in any substantial connection and legitimate interest and so on has been core principles for a long time. But they are new in being presented in this sort of framework and for this purpose. I'm almost out of time. So, but I always, on occasions like this, take the opportunity to sort of shamelessly self-promote some of my writings, and there's 3 excellent books you all should buy, and I list them all here. Almost all that I've said today stems from the middle book that came out a week ago. But I should also mention in the information sovereignty one, I provide a sort of a model for how we should approach the scope of jurisdiction issues in relation to data protection, so that one could be interesting too. I'll try to put some flyers out later so you get some discount on them. But I want to finish on a slightly more serious note. I think lawyers and not least lawyers dealing with internet jurisdiction questions, have too often been focused on preconceived notions of what the solutions are going to look like. And I show this slide very often in that context. We think we know what the solution is going to look like, and that restricts what options we consider. And I think we can learn a bit from kids here. This is a picture of my daughter's attempt when she was about 2 of doing a puzzle. Had she looked at the box, she would have seen that this was not at all how the makers of a puzzle intended the pieces to be put together. But she had no of these sort of preconceived notions as to what the solution was, and with some determination and I think a bit of violence, she managed to put together the pieces in this very interesting pattern. And I think we should learn from that when we try to devise solutions, maybe leaving out the violence part. We should be more creative. We should allow ourselves to think a little bit more creatively, not just assume that we know what the solution is going to look like. And when it comes to internet jurisdiction, we are going to need to re-examine the pieces of a puzzle, and I think we're going to need a few new pieces for the puzzle as well. And that brings me to the end of what I wanted to say. So thanks for your patience.
Okay, Dan, thanks really a lot. I won't criticize you as a radical and nothing else, so don't get me wrong, unless you're also teaching at our university. For that reason, I won't criticize you at all, and I don't have any slides here, so I will be a little bit boring perhaps for you, but just getting back to an intellectual exercise of doing it just orally, and I just react on the very spot here. So let me just begin with this conception of territoriality. You see, pronunciation is really difficult for us. Maybe your findings are also due a little bit to the fact that you're stemming from the common law jurisdiction, from the common law world. So general clauses, etc., are more used now. So you have a really flexible system. But keep in mind that we old continental Europeans, we stick always to these damned codes. You know? So we have to be a little bit specific on some times in that area. But just was the entrance, let's say, the starting. Concerning the phenomena, I will just try to structure it in 3 blocks and don't just be short. So first, what are the phenomena? You're absolutely right, we don't have internet, we don't have borders. But what you see is now a re-territorialization. You see geo-blocking, you see a lot of geo-blocking. This is exactly what the European Union is now thinking about, to have a new directive or regulation or what else, to try to overcome this kind of geo-blocking in the European Union. And so this is really weird to see how the internet is just being segmented now today, that you just have, what do I know, the French internet, you have the German internet, etc. And why? This is just due to the fact that enterprises are seeking to minimize their legal risks, which are stemming from a part of applying extraterritorial, also the jurisdiction. So there's a really point there that geo-blocking, for example, is strictly related also to conflict of laws and to all these problems. Second point, of course you can manipulate. That's right. We all know this. Nerds, etc. You have the VPN, etc. So you can, let's say, present yourself on the internet as a fake American, etc., etc. But keep in mind how many people are really capable to do that. How many people are doing that? Even in the academic world, when my friends are asking me how they can access some, for example, just an open library in the US, because then it's also blocked due to copyright reasons for the Germans or for the Europeans, I'm telling you, you just need to establish a VPN connection or something like that. What is a VPN connection? Can you tell me that? Yeah, can you install me that? Oh, come on, yes, it's just quickly done. No, I don't understand that. So, and you see, for that reason, sorry to say so, yeah, perhaps for the younger digital natives not, yeah, but even then, if I'm, for example, giving talks in schools, etc., you're absolutely sure that 50% or 60% they do not know what the VPN connection is. So you are excluding really people. You can exclude it. Not all of them, of course, there's manipulation, but in fact, this is like a little bit locking a house against other people, and then, let's say, the threshold to overcome the locks is becoming higher and higher. So there is a phenomenon still there, even though you can manipulate. The third phenomenon, what we observe concerning territoriality and a conflict of laws, is the search, let's say, for liability of intermediaries, because you can localize. There you can enforce. You have assets of Google and Facebook, etc., in the European Union. Then you can enforce anything you want to. You cannot enforce something against somebody who's anonymous, etc., etc. So what is the tendency that you can see in court rulings and all across the European Union, that they're getting more and more to the intermediaries? And this is a strong tendency, at least in copyright law, for example, but in other areas as well. So second block, coming now to the general principle. I think there is some sort, and I agree totally to your principles, to your general principles. But we have to be, I think, a little bit to specify them more. Perhaps that goes without saying, of course. That's not a criticism, don't get me wrong. But I think we have a gliding scale, which still there's territoriality principles, even if they're a little bit opaque. Then you have, let's call it, marketed principles, or where something is exceeded to, or you have the download, for example, in copyright law, which I would call in general market principle. This is what we know in unfair competition law, for example. I'm just talking about conflict of laws here. And we know it also in media law, broadcasting. This is an old theory, an old dispute. I think you're very well aware of that. And that is broadly applied to the internet, and I think that's perfectly well done, even though you criticize a lot of the GDPR, but I will come back to this later on. There you have a good point concerning the corporate governance issues, but we will see later on. And then, let's say, the other end of the scale, what you also talked about, is this extreme extraterritorialism, like we have it in antitrust law, when we apply European antitrust law to mergers in the US, and there's just a slight impact on the markets here in the European Union. This is exactly the case now you mentioned concerning the France case, which is now brought to the European Court of Justice. I would be very interested what the outcome of this procedure will be. I hope, to be clear on that, I hope that the European Court of Justice would not accept this French attitude that we are going to regulate the whole world by the GDPR. I think the market principle is well established, but that should be the limit. So please do not apply it on a global level. We already have our experiences concerning antitrust law, which had not been the best in the past, be it from the US side, which they're also applying their laws, extraterritoriality, and which is not really a good thing for us, but we shouldn't do that neither. So once again, it's a gliding scale for me, and that fits, let's say, to your criteria, but then we can specify it a little bit more. What is also at the base, the very base also of the territoriality, and you just mentioned it a little bit, it is, of course, also a question of the perception of human rights. Take, for example, this old case of Yahoo in France versus the US concerning the freedom of speech, the First Amendment on one side, and the other side, the strict restriction or the restrictions concerning the freedom of speech in France, as well as in Germany concerning Nazi propaganda, etc., etc. There you still have this clash of cultures, of beliefs, of values, etc., which is strongly related to the territoriality principle, and we always have to deal with that also in international private law when we have to strike the balance between the different positions. And keep in mind that it's not only bipolar, it's this multilateral questions that we are here confronted with, saying intermediaries are the users, third parties, the ones who are placing their opinion on the net, etc., etc. So where territoriality still, I think, plays a role, even if your criticism is right, I think, is in the core areas of public law. Could be, for example, we had an environmental law. How can we enforce, for example, something public law, yeah, against a French nuclear plant or something like that. That should be very difficult. However, from the German perspective, and my friend Jan von Hein mentioned that already, banking law, for example. If you have a look at banking law, there are some interesting German jurisdictions, sentences of that, handed down by the Bundesverwaltungsgericht, our high federal administrative court, telling that the German banking law, that is to say also European banking law, is applicable to a Swiss bank which is just based, located in Switzerland, but offering the services to Germany. And it's not about, keep in mind, it's not about international private law. They said it is like an establishment of the Swiss bank in Germany. Even if there has been nothing in Germany at all, they just directed their services to the Germans. And so they applied strictly the German banking law, the European banking law, to the Swiss bank. I will come back to this later on because this has implications for corporate governance and this corporate CAO, what you mentioned already. So, to my mind, the market principle, this kind of principle, can I access something? Is it meant for being downloaded there or exceeded there? This is the one we should stick to. Now, coming to private international law. For that reason, has stricken me a little bit, let's say, the topic, which I assume that Burkhard, you just placed it there on the topic, because in private international law, territoriality is not really a general principle. Or maybe I got that wrong. Here are the experts, not me, concerning private international law. But to my understanding, it was never really a general principle. We always looked in your criteria. We always try to establish the balances between the different interests, etc. And so there we derived a set of criteria according to the different legal areas like unfair competition, like personality rights, etc., like copyright, media law, and so on and so on. Thirdly, which is now more for the Europeans interesting here, is the very, very complicated role and the overlay of the country of origin principle in the conflict of law area. Of course, we have this ruling of the European Court of Justice telling us that is not a conflict of law rule. Okay, but what does that mean in practice? So what turns out in practice that every national court is trying to put aside the country of origin principle in any case, so they're still sticking to their national jurisdiction whenever they can, but still it is there, this country of origin principle, and it's still discussed, for example, the media visual directive coming up now in the new proposal. So now coming to the end, concerning third part, your criticism of the GDPR, etc., that no bipolarity is not the real decision, etc., etc. I agree in general, but still the third layer concerning this exclusion, let's say, of administrative sanctions, etc., or corporate governance impacts, I would just call it corporate governance impacts, I would just try to cast a doubt a little bit on that. Because coming back to this banking law principle, why do we have this? Why are we imposing on a corporation this and that structure? Well, that's just simply also to protect third parties, because there you establish an inside balance. Yeah? Okay, to clearly beyond that, this data protection officer is a German baby. Yeah? And it was heavily discussed during the GDPR, and the Germans lobbied a lot, yeah? So for keeping this data protection officers. There had been other member states trying to get rid of that and the regulation at all, so to heal the German disease, but afterwards it turned out that some of a compromise is there. So this data protection officer is only mandatory if you have really highly sensible data, etc., etc. And furthermore, the member states are free to introduce that. But this is a very good point we have to discuss perhaps during the coffee break, because the national laws, like the German Implementation Act of the GDPR, is very opaque here if it really applies to a foreign corporation. Okay, but let's assume that the German Implementation Act would impose on a foreign, for example, Australian or American company, such a data corporation officer. And I would just ask you, why not? Why not? If it's really mandatory for highly sensitive data, if it's really some sort of a, well, conscious, inside conscious of the corporation, this is what we conceived it as that, why shouldn't they comply with it? The same is true in banking law and insurance law. We have also these checks and balances in the corporate governance level, what we stick to strictly because we believe that this is some sort of an inside control. Yeah. Okay. Once again, maybe German disease, German baby. Yeah. But still, I see some reason there. At least we should have some sort of adequacy test, which is unfortunately not in there in the GDPR. Yeah. We could think of that if you just give us evidence that you Austrians have something which comes more or less near, let's say, to this inside conscience, yeah, you see, or officer. If you have something adequate, okay, so then go. Yeah, but unfortunately, we don't have this compatibility test or the adequacy test in there. So, just to sum up, I think we would not argue about your general principles. The problem is more on the second layer, how we're going to specify under which circumstances, which criteria should apply to. And so once again, on the internet, the tendency is clearly that we are not accepting anymore this simple, stupid territoriality principle, but we're applying more or less a market principle. And still, I believe that is, in 90% of the cases, the right solution. Thank you for your attention and not having slides and no books for you to announce.
So who has a question? First here I see a hand and then back there.
Thank you, Tobias Lutzi, University of Oxford. I'd just like to add a very quick argument to the first point made by Professor Spindler, actually an even simpler argument. Because if our mindset as academics is still territorial, isn't the average internet users and the average judges and the average politicians' mindset also inherently territorial? And isn't that ultimately one of the reasons why we see this trend back towards segmentation and geo-blocking and fragmentation? And doesn't it follow from that also that the only question really can be how can we redefine territoriality rather than abolishing it, be it only to gather more support for what I think is the right way forward? Thanks.
Yes, thank you. That is a good point. I must say the main area in which I have been speaking on this topic and getting feedback from all the sort of sectors that you mentioned has been in the context of law enforcement access to personal data in a cross-border setting. So think of a Microsoft warrant case and so on, that sort of area. And what has struck me there is that industry is happy to move from territoriality. There seems to be a bit of a political will, and the courts and so on, the judges seem keen. The ones that is holding back, which surprised me greatly, it's often the academics that seems to be clinging on to their territoriality. I don't get it. We are meant to be the ones that push these ideas that's something for the future, but it seems the reasoning you come across is that no, you can't move away from territoriality because that is what we're used to, but we will never move forward on anything if we just stick to what is the current. And I don't think, as I said, I'm not trying to abandon territoriality as such. I'm trying to move it up a level, in a sense, or down, or however you see it. I don't want to see that as the core of how we think of jurisdiction. And this brings me to what Professor Spindler pointed out, what I failed to mention. Obviously, I see this as just the three core principles of jurisdiction, based upon which we need to have clearer rules in different settings. Some settings, like this law enforcement access to data, I think they can be applied without very much manipulation, some clarification, but they can apply in that setting. When it comes to the framework that I present for the scope of jurisdiction in relation to the right to delisting, I only base it on these principles and have much more detail around it. So that's a very good point that I should have mentioned.
Please. Yeah.
Thank you. Yes, Michael Wilderspin from the European Commission Legal Service. I just want to pick up on a point that Professor Spindler made, which I think is absolutely correct, that you mentioned in your speech that you think your principles are applicable kind of across the board to jurisdiction, whereas I think Professor Spindler is quite right when he says that so far as private international law goes, territoriality is not very important. It's a really subsidiary connecting factor, and that I would take issue with him when he said that what you were saying was affected by the common law, because I, as you probably can gather, I'm also a common lawyer, and I still agree with Professor Spindler, who's about as far away from a common lawyer as it's possible to be. Sorry, that wasn't meant to be a criticism. So I think in terms of private international law, you start from the principle of you sue the defendant where he lives and kind of build out from that. And really, I think where the relevance of territoriality is certainly if you take, say, the Brussels regulation, it's really the application of Article 7.2. You're really trying to locate where damage is. That's the link with territoriality, because you're trying to decide where damage takes place or where damage is caused, which of course is a difficult exercise when it comes to torts that are committed on the internet. And we've seen the Court of Justice grappling with varying degrees of success to trying to apply that principle. I think with the exception of E-date, they've made a reasonable job of it. I think E-date is about the worst possible judgment that it's possible to have, and where the court accepts a thesis which was never argued before it, just on the basis of an Advocate General's opinion. Another weird thing I think about E-date, and that's completely in parenthesis, is whether it is really appropriate to allow an obscure French actor to sue at home in respect of something that's published in an English newspaper, where, in fact, if I recall, the majority of hits on the story were from Australia. Because, of course, most people were much more interested in Kylie Minogue than they were in Olivier Martinez. But I think it's really only in that field where territoriality is relevant in private international law, and it's the only area where sort of cyberspace provides a real challenge. Sorry, I've been a bit verbose, but I hope I've made my point clear.
You want to respond?
Yes. Just very good. Thank you. I think us from the common law systems, we need to make our points quickly before we're not allowed back here. I think it's partly true, but you could also think in private international law, for example, a lot of systems would attach significance to the location where a contract was formed. Yeah, but it's a territoriality type thinking, and it is one that doesn't fit very well in an online environment. And if you look back historically, there has been a great role played by territoriality in private international law. Peter Nye, who you probably, those in private international law is familiar with, wrote some article back in the 60s where he dug into the history of territoriality in private international law and pointed to that back in the days you had to sue where the event had taken place because the jury needs to be drawn from the local pool of people who were in the same grouping and so. So the territoriality has played a big role, at least in some systems, historically in private international law. But I fully agree that private international law has moved further and become more sophisticated than what we see often in the public international law setting often. I fully agree with that.
Sorry, I don't mean to. I agree with your point on that, but I think also it comes back to the issue that cyberspace doesn't. It represents new challenges, but the challenges are not so radically different. Because your argument about a contract was valid only where it was formed it's an old principle, and I think Italy hung on to it for a long time. But of course, challenges to this were first presented not by the internet, but by the telephone and telex and fax and so forth. And in a sense, the principles that have evolved to deal with that can, to a greater or lesser extent, also be adapted to deal with cyberspace.
Okay, we have time maybe for one more question. Yes, up here.
Thank you very much. Christian Kohler, University of Saarbrücken. I would like to understand better your criticism addressed to Article 3 of the data protection regulation. You characterized a territoriality principle as destructive, and you proposed the 3 elements for a better approach to that point: the substantial connection, the legitimate interest, and the reasonable exercise of jurisdiction. If I look at Article 3, I see it's an incarnation of these 3 principles, and I would, if I look, perhaps one might discuss whether Article 3.2, the exercise of jurisdiction to prescribe, if the connecting point is only the monitoring of the behavior of the interest consumer or people in Europe, then one might discuss whether this connecting point is has sufficient weight. But on a whole, I think Article 3 is an example for a substantial connection, for a legitimate interest to prescribe, and to more or less a reasonable exercise of the jurisdiction. Of course, you might now transpose these ideas if it comes to adjudicative jurisdiction. And then we have the common law and the civil law divide, where civil law lawyers would not very much like to engage in flexible connecting factors and discussing everything. But here also, what would you say if you look at the situation in Europe, if you transpose it on the adjudicative jurisdiction side? Would, for instance, reasonable exercise mean that there should be a test of what you might call forum convenience or forum non-convenience in third country related internet cases? I would very much like to hear what you think about that.
I think we'll hear Dan's response and then we'll go to the break.
Yes, I'll be brief because everyone is very deserving of coffee by now. I think we see things differently. If you see Article 3 as a recognition of my principles, I don't see it that way, and I think maybe over coffee we have to go into more details on that one. I think Article 3 is terribly broad. Leaving aside this lacking sophistication that I mentioned, that it should be layered, I think it's also overly broad, and the result is going to be that the EU has jurisdiction over a lot of matters with very little connection to Europe. Monitoring of behavior is a very good example, as you mentioned, and the EU is not going to be able to enforce its law in this setting. So the only ones who's going to be affected by the regulation is the big players that are caught anyway. Almost any jurisdictional hurdle you would devise, Google, Facebook and so on would satisfy them and would be regulated. And then it's going to be the players on the European market from outside is going to be the ones who don't care about following the law. The ones who want to be abiding by the law from outside Europe will find it too expensive if you're a small to medium operator. And I think that we should have had much more nuances in Article 3 to avoid that sort of setting. And we should also, one last point, sorry, we should also remember that the rest of the world copies what you people do here. Yeah. So don't be surprised when the laws of all the other countries in the world start adopting very broad extraterritorial reach of their data privacy laws. And while Europe has the strictest as a whole, you should not assume that complying with European data privacy law means that you automatically comply with the laws of all other countries. In places like Trinidad and Tobago, they beat you. They implement a fine of 10% of annual global turnover. So you wait till you've been taking action against you there.
And I think Gerald Spindler wanted to have maybe the last word.
Okay, there would be a lot to comment on that, but we really leave that to the coffee break. I just wanted to add another point which yet hadn't been discussed, as the colleague of the European Commission just mentioned, the e-data decision. And unfortunately, this had been absolutely not discussed the conflict between personality rights on one side, like the e-data decision, and the treatment under the GDPR, because the sources of it, if we look at it from a more abstract point, are the same, but as different principles that we apply here, because the GDPR also introduces in some way claims, private claims against players concerning data protection. But there, different principles then apply, or should we align them, or what? There's nothing in the GDPR about that. Is it now falling under the Rome regulation? Is it being governed by Article 5? Is it the same as in the e-data decision, or how can we strike here the balance, how we can find parallels between these different areas? You see what I mean? Because then we could have a case where, like in e-date, you see the Center of Personality Rights, what do I know, in Spain, but concerning data protection would be applicable in Austria and in Germany. So could we find then now a civil claim also in Austria and Germany, but violating then the e-data decision? You see, that's for me the point that has absolutely not been discussed. And as far as I know, please, my experts here in Private International will correct me if I'm wrong, but I'm not aware of any article, be it in English, be it in Spanish or in German, discussing this collision, let's say, between the core principle civil regulation or civil law on one side and the GDPR, which has its hybrid, which is public as well as private law. I've never seen that. And so maybe we could discuss that also.
Actually, last word is Dan.
No, I just want to say there is an article in this fantastic IDPL publication, International Data Privacy Law. There is one article by Maya Bracken. Yeah.
Okay. Excellent. Well, we like to be on time both at the Max Planck and at the Brussels Privacy Hub. So with that, thank you to both Dan and to Gerald for your great contributions.